Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, can I enter into a prenuptial agreement or other contract in Connecticut with my partner if we aren't planning on getting married?
That's a good question, Emily, and it's a fairly common question. Often partners are wondering, can they enter into a prenuptial agreement if they don't intend to get married? Or if not, is there any other contract that is available for individuals who don't intend to marry but still want to address what their property and financial rights would be in the event of a separation? These partners are often in long-term relationships. They're generally living together. They may even have children together, and they're often pooling resources, sharing expenses, commingling assets in a way that they really need some kind of clarity as to what will happen with their finances, their debts, their expenses, their assets in the event of a separation, the same way that married individuals are seeking that kind of clarity by entering into a prenup or a postnup. Well, in Connecticut, the law doesn't recognize what's known as common law marriage. Common law marriage is generally when two unmarried individuals are in a relationship for a certain period of time, after which the law would generally recognize their relationship the same way it recognizes the relationship between two married individuals or spouses. So it may confer onto them certain rights and obligations that the partners would not otherwise be entitled to unless they were legally married. As I said, Connecticut does not recognize common law marriage, and therefore cohabitation or length of a relationship or even having children together doesn't confer onto two unmarried individuals in Connecticut any kind of legal duties or rights and obligations as to any finances or property that they may be commingling in the absence of actually formally getting married. And so these parties are often in a situation where they're not eligible for a prenup or a postnup to address their financial and their property rights in a way that they would want to do so in order to prevent any kind of disputes in the event of a separation or protect themselves. A postnuptial agreement is generally reserved for individuals who are actually married, and a prenuptial agreement is reserved for individuals who are contemplating getting married. And generally, prenuptial agreements do not take effect until and unless the parties actually marry. So, in the event that these partners want to enter into a prenup, it isn't going to help them unless they actually get married. It wouldn't be an effective agreement unless they actually marry. And so sometimes these partners, not only are they not married, they may never intend to marry. And so a prenup is not going to help them get any kind of clarity or protect their rights and obligations. So what they can do in Connecticut is enter into what's known as a cohabitation agreement. Now, Connecticut law, while it doesn't recognize the right of these individuals to enter into a prenuptial agreement or a postnuptial agreement, it does generally recognize the rights of individuals to contract, right? So you can enter into an employment contract, a contract for the sale or acquisition of a property, for example, a contract for the purchase of a home. You can enter into a lease between two renters and a landlord. These are all different kinds of contracts, and so a cohabitation agreement is another example of a contract. Generally, it's reserved for individuals who are cohabitating together, as the name says, and they need to be in some kind of intimate or sexual relationship. So it can't be between two individuals who are roommates who are just splitting rent and utilities. The cohabitation agreement is really meant for individuals who are doing more than just living together. They're in a relationship and perhaps commingling assets, etc. While the renters can enter into a lease, that would be their option. A cohabitation agreement can address many more issues than a lease can address because it's really going to what the property and financial rights of the parties are. The same way perhaps a prenup or a postnup would. Now, in Connecticut, contracts can be either express or implied. So, a cohabitation agreement, being a contract, can also be express or implied. An express contract is generally, we see it as a written contract, but it can be a spoken contract. But it would either format, it would express what the intent of the parties is or what the understanding of the parties is. An implied contract is perhaps not so clear. It's not written. It's implied by the conduct of the parties. And so we often see situations where perhaps two partners are living together for a certain period of time and they're conducting themselves in a certain way with regard to their finances, perhaps sharing expenses, as I said earlier, pooling resources, acquiring assets, and contributing to those assets in a certain manner. And so perhaps in the event of a breakup, one party would say, well, I'm entitled to a certain certain portion of these assets, or I am not responsible for all of these debts, even though the titles to the debts or the assets may be held in a way that may make that unclear. And so the court can look to, well, A, was there an express contract? Was there an explicit understanding as to how these assets were going to be managed or how the debts were going to be managed in the event of a separation? Or was there an implied contract in the absence of an express contract? What can the conduct of the parties tell us about what their intent was and what the arrangement was, if any? As far as an implied contract, it's a bit more complicated to be able for the court to discern what the actual arrangement was. So the court will have to assess a number of different factors. It will certainly look at how the finances were managed or handled between the two parties. Were they commingling assets? Were they sharing expenses? And if so, how? But they can also look at how the parties interacted with third parties as to their financial circumstances. So, for example, did they refer to the home as our home, or did they refer to it as his home or her home? Did they refer to a debt as our debt, or did they refer to it as his debt or her debt? These different things can really help the court assess what was the understanding of the parties during the course of their relationship in order to determine what their rights or obligations or duties would be in the event of a separation. Now, it's important for the parties to understand that this is certainly a much more difficult inquiry than if the parties had a written agreement that explicitly dictated what their rights and obligations were. So though a court can certainly still find that there was a contract or some kind of enforceable agreement between the parties, if it was implied by looking at their conduct, really best practices to enter into a written contract to avoid any kind of uncertainties, ambiguities, or disputes in the future in the event of a separation. It's just a cleaner, more thorough way to protect yourself. Now, these agreements are often subject to enforcement actions in the event that one party claims that there was a breach of the contract. So a common way this plays out is perhaps two partners move in together, but they're moving into a home that one of the partners owned prior to the relationship. And now both partners during the course of that relationship are contributing to the property. Perhaps they're both paying the mortgage, they're both paying utilities. They are both perhaps even contributing to things like renovations. And then they separate, and the party who's the non-owning party says, well, I want reimbursement. I want to receive reimbursement for the value that I added to the home. Perhaps I want 50% of the equity or 50% of the appreciation that accrued during the course of our relationship. And the owning party says, well, this is my property. I don't owe you anything. This is you voluntarily contributed, but it wasn't my understanding that you were going to get any kind of benefit out of it other than living in the house with me. So this is a circumstance where the parties often end up litigating over who is entitled to what or who's obligated to do what. And the court, as I said, would make an inquiry as to what was the arrangement between the parties, what was the understanding, and how were they conducting themselves during the course of the relationship. The court here really wants to ensure that both parties are going to receive essentially the benefit of their bargain. And they want to ensure that no one party was unjustly enriched at the detriment of the other party. And so to the extent that the court can determine that there was some kind of an agreement and there was a breach of that agreement by one of the parties, the court will essentially try to put the parties back in the position that they would have been in the event that neither party breached the agreement. And so this is really centered around this theory of, or this principle of restitution, where the court is going to order the party who may have been unjustly enriched or otherwise received a benefit that they weren't entitled to essentially repay or reimburse the other party for their share of the deal, their benefit. And so the parties, in order to ensure that the court can actually conduct a proper inquiry and come to the correct assumption as to what their agreement was or what their arrangement was, it's really best to put it in writing. This leaves less guessing for the court to have to do in determining was there an implied contract, and if so, what were the terms. Now, as far as this, the contract, it's certainly subject to certain laws in Connecticut that would govern what kind of issues can and can't be addressed within the agreement and what the form of the agreement should be. The same way prenuptial agreements and postnuptial agreements are subject to these kinds of laws under Connecticut law. So it's important for the parties, if they want to enter into an agreement, to consult with an attorney to ensure that they are only including provisions that would be enforceable and not otherwise invalidate their agreement. And it's really important for the parties to consult with an attorney if they believe they are a party to an express or implied contract with either a current significant other or a former significant other, and they think that there may have been a breach of that contract. And it's important to consult early because some of these issues, some of these claims may have a statute of limitations that applies, which means that after a certain period of time, you're no longer able to go to court and seek pursue any kind of claims or seek any kind of reimbursement for what you think you may be entitled to. So certainly these issues can be very time sensitive. It's important to consult with an attorney, as I said, as early as possible, as soon as you realize that you may be a party to one of these contracts and you need to seek enforcement.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.